I have a question on C44 that you had on the screen just a moment ago. If I may have your attention, you had the C44 at the bottom of
Yes,
the
sir.
document list on my screen that you had underlined. It says modifications.
It's I believe it's clause 6. If we can go to that, please, so that
they say they shall decide on the following issues:
yes, sir.
modifications to the onerous usufruct contract, etc. Yesterday we were told that the contract was null and void by your expert, that it could not be corrected or made legal, to say it in simple terms. Why would you bother to modify it?
As I pointed out, Mr. Chairman, I believe that this is a draft document. So from everything that we understand, what the modification would mean would not be a modification of the existing agreement, because that agreement on its face, based on the illegalities, can't be remedied. But the idea, as I understand it, was for the parties to enter into a settlement in order to execute a new usufruct equipment contract and celebrate a new public bid that would take away or basically deal with the problems that caused the agreement to be lesivo. As evidence of that, I point you to R36 and R37, where immediately post lesivo, when the parties actually do sit down to discuss the issue of the equipment contract and its illegalities, that is precisely what the parties were discussing. They were discussing the execution of a new equipment contract. And as I pointed out before, document R37, and you'll see if you go through it, the minutes at R36 and R37 of the meetings that took place just after the lesivo declaration, in R37 you see that FVG, through Mr. Sen, said that they really weren't too interested in doing that because, as Mr. Sen said, that was of secondary priority to them, given that they wouldn't need the rail equipment for Phase 2, because that would be standard gauge.
Thank you. She defers to you. You are the professor here.
Mr. Otto, the parties are agreed that if the tribunal were to award damages, it would be appropriate for the claimant to return its assets, cancel its contracts, etc. in Guatemala. Now, one can understand the juridical basis for that in the event that we found an expropriation. And you might say that if the parties are agreed, then it's not a problem finding a juridical basis. But let's assume the parties were not agreed. And let's assume that the breach that was found was a breach of the fair and equitable treatment standard. On what basis could we condition an award of damages in relation to the return of the property?
You just bear with me 1 second. Professor Crawford, again, we think that the appropriate standard under CAFTA is the fair market value analysis, and so I think, again, based on that question, the tribunal would be answering what is the fair market value of the investment at the time of the act. Why do I say that? Because the discounted cash flow analysis, as we've pointed out in both in our memorials and in the report of Professor Spiller does provide full reparation to the parties, and so and in this case, in this instance, to the claimant. So we believe that that would be, in the first instance, the correct standard for the tribunal to apply.
Fair market value implies that you've lost the investment, whereas you can have a breach of FET which leaves you with the investment. The investment may be worth less, maybe a lot less than it would have been had there been no breach, but it's not necessarily worth nothing. And the problem, and I'd be interested for enlightenment, because in another case I basically left, or the tribunal basically left the claimant in situ, having awarded damages for breach of fair and equitable treatment, and therefore didn't resolve the dispute between the parties. Now, I understand this is slightly academic because you agree between you that whatever the basis for recovery might be, if there is any, that condition should be attached to it. But I'm interested in the theory of the claim, bearing in mind that you could have a breach of fair and equitable treatment which led to a recovery of a small amount of money, or the recovery of virtually the entire investment.
Thank you, Professor Crawford. I have two different things to suggest there. The first is, and this relates to, I guess in part, the slides that we put up just toward the end. But if the tribunal, under that circumstance, for example, were wanting to consider a remuneration or a I guess an evaluation of a possible remuneration to claimant based on their capital contributions, their net capital contributions, I think in this particular case, you'd have to take into account the fact that the claimant made investment early on in 1999 and 2000, and I think, as we heard from Professor Spiller, there were some perhaps minor additional investments of about $500,000 in 2000, 2001, and then the investment stopped. And what you have after that is simply capital contributions to cover losses. So, I mean, I think in that circumstance, it would be it would be difficult to determine what would what if anything the claimant in this case should be awarded, because by the time you get to 2006, through just the actions that took place in relation to their investment in Guatemala, the lack of demand and lack of financing and funding and other things, they had really basically already burned up the investment that they had made, and they were staying afloat, as I say, by asking their shareholders, in particular their principal shareholder, to contribute to keep them afloat.
Sorry. Another concern relates to the question what would have been the subject of an expropriation in the event the tribunal were to find an expro. The equipment contract is a separate legal document, and in the event that there was an indirect expropriation, it is at least arguable that it was limited to the equipment contract or to the legal interests associated with it. After all, at least in theory, the claimant retained its rights in relation to the right-of-way for other purposes, and it's agreed that the value of the commercial interests associated with the right-of-way were potentially greater than in relation to the conduct of the railway. It would be a somewhat Solomonic verdict to say that the expropriation was limited to the equipment contract, but I'd be interested in your comments on that.
Professor Crawford, I I think we agree in this case that the contract that's at issue, we understand the claimant has a different viewpoint, but the contract that's at issue that was declared lesivo is the equipment contract. And we believe that there have been a series of concessions made in relation to Contract 402 that establish, by claimant's own words, that it's wholly unconnected to, the substantial part of their revenue, the real estate, is wholly unconnected to the entire railway operation. Now, getting directly to your question, the equipment contract at issue here was entered into in 2003. And as I mentioned, by that point in time, the claimant was no longer making any investment per se into the railroad operations. They were simply funding through capital contributions the shortfalls that they were having in order to stay afloat. So I think in relation to the declaration of lesivo of that agreement, what we're really faced with is an issue where they could only use that equipment to operate Phase 1, and Phase 1, by their own admission, produced only losses. In relation to the operation of the train in any other phase, you've heard that as to Phase 2, it would require different equipment. So this has no effect on that. To the extent there's an expropriation or some wrongful conduct under CAFTA in relation to the railway equipment contract, it doesn't affect their ability to operate in any of the other phases per their own admissions. So you're faced with an issue where you have equipment that perhaps they can't utilize in Phase 1, although again we claim they have every right to do that today. They could be operating the trains today in Phase 1 if they hadn't left the country. But in any event, it's in relation to a phase of operations that, as a matter of record evidence, they have admitted on a number of occasions produced only losses. So again, if you apply fair market value to that, you're still going to get a negative value.
My last question relates to the role of this tribunal relative to the question of the declaration of lesividad. Now, obviously, as an investment tribunal, this tribunal is entitled to apply Guatemalan law, provided it can be satisfied as to what it is. And in effect, it might be argued that what we're having to do is to do what the Guatemalan courts should have done if they'd decided the claimant's case on the lesivo issue at an appropriate time rather than delaying, as they seem to have done. But it's not beyond the bounds of possibility that one might say that the lesivo decision, though it seems from the outside to be harsh and unreasonable, was a decision which Guatemalan law mandated. If we were to take that view, what room is there for any recovery at all? This goes back to a question I asked you this morning, where you said we didn't need to decide the lesivo issue, and I said we may not need to decide it, but if we did decide it, surely it would be relevant to the case. I mean, I don't want to put your case higher than you've put it, but I just would appreciate any comment you have on that scenario. I should say that these questions are asked to the claimant as well.
If you just give me 1 second to ponder that, Professor Crawford.
These questions are asked to you as well, so you may in due course like to comment on them. You won't have to, it's to be done today.
All right, here's my best shot. So if this tribunal were to determine that the Lesivo declaration was proper in terms of Guatemalan law, then it's our contention that there would be no conduct, no offense, no conduct that would have offended the claims under CAFTA, because first, as it relates to expropriation, they still would be in possession of what they have admitted is the biggest part of their investment. So even if you admit, or even if you allow for the position that this has affected their ability to conduct railway operations in the first phase, which is the only phase, as a matter of record, that they would be using that equipment to begin with. That, per their own admission, would represent no more than 8% of their revenues. And so there would be no expropriation because it wouldn't be substantial enough. And in any event, you're ruling that it's proper, so there's no improper conduct that would be violative of CAFTA to begin with. And I think that would take care of the inquiry with respect to fair and equitable treatment. And with respect to the other claims, full protection and security and national treatment, again, I think those fall away just by their inability to meet the elements. But on expropriation, given the substantiality requirement, I think that claim would fall away because they couldn't meet the threshold element that it would have to be substantial enough, the effect, so as to allow for compensation to begin with.
Thank you very much.
Thank you.
Sure. This is your turn.
I'm afraid we're going to get a bill from Cambridge at the end of this for this seminar.
From Cambridge, it will be a very modest bill.
Let me go back to one of your first questions about the effect of a decision on the existing leases. The way I answered the question this morning was, and I hope it was because I intentionally chose my words carefully as opposed to sheer accident. But what I said was that if you awarded full reparations, however you define that, if you awarded full reparations, whether it's for whatever state action that violates international law, once you award full reparations, then the payor of those reparations, the state, is subrogated to all of our rights under the contracts, it seems to me. Therefore, it seems to me that the fashioning of your award to the extent that you concluded that what you were awarding were full reparations, fashioning it in that fashion, you would automatically cause Guatemala to be subrogated to our rights under the leases. So that would be my comment on that one. On your more recent question, I believe it was one of the drafters of the articles on state responsibility. I certainly hope it was you, but I can't remember which one it was. But I think one of the things that was said was that a government can't rely upon necessity under its own internal laws to justify a breach of international law. And so even if the declaration of Lesivo might have been legal under Guatemalan law, then you still have to examine it under the applicable principles of international law. Except for the time, for example, putting the time period aside, they have apparently complied with what they think Guatemalan law is in connection with the declaration of Lesivo, but that doesn't mean it satisfies the requirements of customary international law.
It was Roberto Argo, but I agreed with him, so the rule survived. Thank you.
I think that what I'd like to do is organize my questions by, rather than going one by one, giving each of you a series of questions. And I have every reason to believe you'll both take good notes, and that unlike some of the witnesses, you will be direct in answering rather than feeling you're paid by the word. So let me, for the claimant, ask the following, and these likewise are in no particular order, and I've gone over some of this in your original presentations, and I'll try to avoid being repetitive. First is whether there is a tension in your two themes of why Guatemala issued the Lesivo Declaration. On the one hand, you seem to argue that the process was designed to extract additional concessions that went beyond 143 and 158, $50 million, for example, development of the South Coast, and so forth. On the other hand, you argue that the purpose of the exercise was to transfer control to Mr. Campayo, and I would like to ask whether there is any seemingly conflicting objective here and an inconsistent argument about what their motive might have been. Second to the claimant is that once Lesivo was declared and you issued you had your press conference and your press release, one might have thought, since the principal benefit of your contract was in 402 and the right-of-way, which was at least not directly related, that you might have tried to reassure your financiers, your suppliers, your customers, that you were there to stay in Guatemala to develop this most valuable piece of your contract, that you already have contracts which continue to this day and which, as we've seen, have increased in revenue, and that you become, in effect, a real estate developer. Now, you mentioned earlier that you wanted to do the right thing and give Guatemala an operating railroad, and that's why you really invested more than the minimum amount you could. But at this point, it's difficult for me to understand the thinking behind your declaring that you were a dead man walking, because that would seem to make it more difficult for you to obtain rentals in the future, or keep squatters off, or collect from squatters even now. Third, and this may relate to something James got into, but if we were to conclude that the government acted unreasonably but did not sufficiently impair your investment, how would you propose that we go about looking at a damage analysis? How would it differ from the damage analysis, if at all, if there were an expropriation? And how would that damage analysis be implicated by your obligation to mitigate your damages? Then for the respondent, there seems to be a clear difference in what each party believed the original contract obligated Feravias to do, the one phase versus the 5 phases. But the contract seems to talk about initiating rather than completing work, and there was evidence introduced by the claimant in which it appears that FEGUA specifically confirmed that Feravias had sustained its obligations on phases, at least on phase 2, and perhaps at phase 3 was not possible to succeed. So I'd like to have your thoughts on that, not what you hope to get, but what did the contract actually require, and why was it that FEGUA seemed to have put its imprimatur on the claimant's fulfillment of that. I would like to hear you and this actually I think both is on the power and authority of the overseer of FEGUA when he signed 143 and 158, signed the letter authorizations, accepted canon payments. If you're saying that he acted in some ultra vires way, nevertheless, what should the tribunal conclude in the fact that he was an official of the contracting party here? Next, to the respondent, it appears to me that there were sort of 3 opportunities to get this contract right, which was a contract that at least seemed to me initiated by FEGUA, certainly signed by it. In 41, they didn't apparently get the presidential approval. And perhaps because they didn't, they then wrote 143 and 158 not to require it. At least that's what Mr. Gramajo, I thought, said several times, very, very strongly. It did not require presidential approval. And maybe the reason it didn't is because they had tried to get it under 41, and the previous overseer was at the door as the hourglass was running out on the administration, which I've participated in too, and couldn't get it. And maybe that was why. And then in C-44, when you come up with this a proposal which went well beyond correcting the defects of 143 and 158, you yourself said that there was a mistake made. It was a draft, certainly. You can see it was a draft, as you point out, in saying that a mistake with respect to whether there was a requirement for a bid. I mean, how many mistakes can one keep making here? And the lawyers who presumably wrote 143 and 158 not to require presidential approval then come up with the notion that it is required, and there's no way to get it, apparently, under Guatemala law without rewriting the contract. So if you could address that, that would be appreciated. Then I want to see if you can make our job a little bit easier on some of these standards if we have to get to it. Under the fair and equitable standard, there's a very vigorous debate about what customary international law means here. But for our purposes, is there essentially an agreement that whether you look at a freestanding standard or others, that you'd be still applying a standard that would incorporate protections against arbitrariness, non-transparency, and frustration of legitimate expectations? And I would ask both parties that. And then the last issue where, again, you might be able to make our life a little easier if we can narrow the differences. And that is the standard if we were to find an indirect expropriation. The respondent, quote, cites to a paragraph in RDC's reply that quotes the following language from Vivendi 3, quote, "This tribunal will have to determine whether they affected a substantial permanent deprivation of the claimant's investments or the enjoyment of those investments' economic benefits." So is there an agreement between you that that is essentially the standard we should be looking at for indirect expropriation? And then I guess the last issue, I wouldn't really go back, although I think you've answered it, but it's still a question in my mind of why, if the defect was in 143 and 158, so much time was spent on issues that involved 402 and 820. And in that respect, my last question would be just factually, has either party, my understanding it is under 802 there was an obligation for both parties to pay into the trust fund, did either party pay into the trust fund, and when? Now, I'm going to conclude with that, but I'd be remiss if I didn't add one other personal thing. And that is, I think that the quality of the legal presentations has been extraordinary on both sides. I think you've each done a tremendous job of representing your clients, both in the written presentations and the questions and the demeanor you presented, in the insightfulness of your arguments, and I want to congratulate you for really a very, very high quality of representation of your clients. That's not a question, so you don't have to.
But it deserves an answer. Thank you. David is looking at me as though he wants to take the second shot rather than the first shot. So I'll take the first shot. And your first question was about a potential tension between our themes, and I think it'll come as no surprise to you when I say that I don't think that there is a tension. That there was a perfect storm of confluence of interest here. On the one hand, Dr. Gramajo wanted control. He didn't like at all the fact that Ferrovias had control of assets that he wanted to have control of. On the other hand, Ramon Campollo, he didn't really care whether we invested the $50 million or $100 million or how much ever it was in order to rebuild the South Coast for his benefit, or he took it away from us and could then do with it as he wanted for his benefit. He was clearly interested in the South Coast aspect of the line, And so he didn't care. And that coincided perfectly with Dr. Gramajo's interest, because he wasn't interested in the South Coast because it was going to be a wide gauge railroad, and his interest was in the old locomotives and the old cars for the Fagua Railroad Museum. So I think that in fact I think, as I read the evidence in any event, those paths, while they started out differently and perhaps without coordination, as time went on, they converged. And I think what you see from the timeline of the Campollo-Pinto involvement, if you go back and look at it, that they started out, I think Mr. Campollo was pretty much a lone wolf back in 2001, and that was before Dr. Gramajo even got involved. But Campollo was interested in the deal. Then Gramajo gets involved when he becomes the overseer, and he has an interest in getting rid of Ferrovías. Campollo has an interest in getting rid of Ferrovías, and their paths inexorably converged. Yes, thank you, Kevin. Your second question had to do with the press release, and you said since the prime benefit was in Contract 402, why didn't we do more reassurance and so forth? Well, remember that a lot of, as you said, the financiers, suppliers, and customers. Well, the customers, the railroad customers, as to which we presented evidence, they weren't concerned with 402, except in a way that I will explain. They were concerned in the operation of the railroad, and the equipment contract was specifically, would have been their interest. The financiers wouldn't have cared which contract was under threat. And all of this is, if anyone really understood what was going on. You will notice in those various and sundry press reports, the president doesn't say, I'm declaring contract 143158 Lesivo, but I want $50 million investment under contract 402. No, nobody was focusing upon that technicality at the time. That technicality is, or that difference is something that we're focusing on here. And the fundamental issue, I think, is that they were, as the witnesses have, I think on both sides, have described, they were inextricably intertwined. If we don't have the equipment, we can't run the trains. If we can't run the trains, we default under 402 because we can't provide service. So we lose the real estate one way or another. It doesn't make any difference. Now, turning to the press release itself, Kevin says, and I think he's right, that you really need to read this press release in its entirety so you get the flavor of what was being said. And one of the things that was said in this press release, and while just before I say this, let me point out that remember the press release when it was issued on August the 28th was in English, and it appeared only on RDC's website. It was not published in Spanish until the publication on September the 4th in Prensa Libre. So I point that out, not that I think it is it's critical for the question you're answering, but just to get the context right. But the press release goes on to say, this is now more than an investment for us. It is a struggle for justice. We remain convinced that the railway plays an important role in a country that abandoned its railway in 1996 and currently does not depend on either unrealistic schemes or government subsidies. For this reason, we will not only continue to advocate for the implementation of our business plan as we originally conceived it, but also to fight for the right to do so against a government that has gone out of its way to obstruct our progress by violating the terms of the Railroad Infrastructure Trust and begin something that will ultimately result in the expropriation of our usufruct. This is a commitment we have to our 62 shareholders, our customers, and our employees. We also have this commitment to our country, not only as a company formed to provide much-needed strategic transportation infrastructure, but as individuals opposed to a culture of corruption and denial of justice. So this press release was saying two things. Number one, it was assuring our customers, our suppliers, and others that we were committed to this fight. We weren't packing up and leaving, as Mr. Orta would have you believe. We were saying publicly that we're not going to pack up and leave. We're going to stay and fight. And number two, I think that from the language of this press release, it is very obvious that the purpose that I described earlier today, that we were trying to put pressure on the government in order to cause the government to reverse its decision. And that's the thrust, I think, reading the press release as a whole and fairly interpreting it, those are the two thrusts of the press release. Now, the third question was, if the government acted unreasonably but did not sufficiently impair the usufruct, how do you look at the damages analysis? Is it different? And how is it implicated by the obligation to mitigate? Well, let's suppose, for example, you concluded that the denial of fair and equitable treatment was such, and in particular that it was based upon a frustration of legitimate expectations, and that in effect we had been led down the river and ambushed. And you concluded that in that case, for example, you might conclude either one of two ways of looking at damages. One, you could conclude that that denial of fair and equitable treatment was so complete because the declaration of Lesivo so completely destroyed the business that you were going to award the measure of damages that we've urged you to award, which is both the return of the investment and lost profits with the amortization of the investment. On the other hand, you also could conclude that you were going to put us back in the position as if we'd never made the investment. This was the suggestion that Professor Crawford made the other day as a potential way to look at a measure of damages, and I think it's particularly relevant to a fair and equitable treatment analysis. Now, if you decided to do that, to put us back as if we hadn't made the investment, then it seems to me that you've got to do three things. Number one, you've got to give us our investment back. Number two, you have to give us what we would have earned on that investment if we had had it, and we are in the business of doing what we do, and you have a weighted average cost of capital computation for that business, and I would suggest that you have to use that to bring the investment to its value in 2006. And the third thing, if you're putting us back in as though we hadn't made the investment, then we wouldn't have spent the legal fees and had the cost and expenses of the arbitration either. So I think that there are implications for the necessary components of the award. In other words, I think that fees and expenses are a critical component if you look at it that way, whereas and they don't even go to the question of looking at it to see, the general balancing test that you would use for awarding fees and expenses. And mitigation, I think mitigation applies to everything. We are not contending that Professor Crawford intimated that an argument could be made that in a fair and equitable treatment analysis, if you found that that it hadn't completely destroyed the value of the investment, that then in those circumstances we might be left in the position of continuing to collect under our leases. I think that is an accurate analysis if you came to that conclusion. But if you come to the conclusion that we're urging you to come to, that the denial of fair and equitable treatment essentially destroyed the investment, then I think mitigation always applies. So the issue of mitigation will depend upon how you approach this whole question of what portion, if not all, of the investment was destroyed. Power and authority of the overseer, I'm not sure whether that's a question you directed to us, but I'll briefly say something about it. As you know, our expert has testified that this is an autonomous entity. And as an autonomous entity, the overseer of FEGUA has all of those powers and authorities, and that's the reason why our expert testified that no presidential approval was required, because it's not necessary. The overseer has those powers. You asked the question about how many mistakes can be made. Well, candidly, I don't think they were mistakes, but that's more a question devoted to Mr. Orta than to me. Under trying to agree on a standard under customary international law with regard to fair and equitable treatment, we certainly believe that both arbitrariness and bad faith. You didn't mention bad faith in your recitation of the standards, but we certainly think that bad faith is a part of it. Non-transparency and frustration of legitimate expectations. We believe all of those are important. And insofar as the standard in indirect expropriation, I believe the parties agree that it's a substantial. I don't know that we agree that it has to be permanent. I think it has to be of substantial duration. In fact, I don't think the cases support the idea that it has to be permanent. It has to, but it does have to be of substantial duration. Deprivation of the investment or the enjoyment of the reasonably expected. I believe the cases use the term reasonably expected benefits of the investment, and we think that's what the standard is. Your last question was, did we pay into the trust fund? And the answer is yes.
Thank you, Mr. Forster. The court reporters have asked for a few minutes break, however limited. So I will, but 5 minutes. I'm not suspending the session. Whomever needs to leave the room may leave, but come back right away.
Now I know why David wanted me to go first.
You have the burden, Alan.
We are continuing with Mr. Orta.
Thank you, Mr. Chairman. I'd like to start with thanking Secretary Eisenstadt for the observation he made at the end of his comments about the presentations we made. And I think I speak on behalf of the entire team on the respondent side. I very much appreciate the comment. In response to the first question, as I understood it, Secretary Eisenstadt, you asked what our view is in relation to what the restoration obligations were under Contract 402 in relation precisely to what the contract says, and also I believe you asked about the letter in relation to Phase 2 that had been that's been a matter of record. So I'll start with acknowledging that in the contract, it's Contract 402 and it's paragraph 13 or Article 13 of the contract. Every single one of the restoration clauses in relation to Phase 1 through Phase 5, they all have the same verbiage. And they all state that the usufructuary has the obligation to begin, bear with me, let's make sure I get the language correct. Perfect, yes, thank you. So it's up on the screen now. It says, and notice that it's the same in relation to Phase 1, which is the very first one, as it is in relation to Phase 2, 3, 4, and 5. And they have the exact same verbiage. Shall begin restoration within X period of time, and it defines a different period of time for each phase. And then at the end of each, it says that, let's see here, so it says that, bear with me, railway cargo transportation shall be offered in relation to the phase, shall be offered in at least one segment within a 6-month term as of the date that that phase is supposed to begin. Now, we start with it. The clause doesn't say when the restoration is supposed to be completed, or quite frankly, on its terms, whether it's supposed to be completed. But from our understanding of what was bid out and what was negotiated, the Guatemalan government put out a bid for restoration of its railway and gave the land to FVG in order to carry out the restoration. Now, it appears that in the drafting of this contract there's a lacuna. It doesn't say what when exactly the phases are to be completed, but it doesn't say they're not to be completed. It doesn't say they are to be completed, and it's our understanding. I'll start with what our understanding of Guatemalan law is. In a situation like this, where you have a void in the terms of the contract that make it such that, and this is again, it's a stark difference between civil law systems and common law systems in relation to this issue in some regards. And in civil law systems like Guatemala's system, when you have a void like this, and when interpretation of the agreement is you're unable to do so, or the interpretation would be unreasonable given the void, and we contend that the interpretation that's been given here by claimant, which is that they only had an obligation to begin rail restoration service in the first phase and to complete it, but not in any other phases, first of all, is internally inconsistent because, as I mentioned, the language is the same as to Phase 1. Phase 1 doesn't say you have to complete it by a certain date, but yet they take the position that they were obligated to complete Phase 1. So if you look at just the language in the contract, I suppose you could ask, well, why are they concluding that they have to complete Phase 1 but not the other phases when the language is precisely the same for each phase? And going back to the interpretation point, given that there's a void here and given that the purpose of the agreement was to restore the Guatemalan railway system and that the land that was given, I should say the right to exploit the right-of-way was an auxiliary or secondary right that was given in relation to the railway restoration, I think we have to look to what the parties intended. And when you look to what the parties intended in order to fill that void, the only evidence that we have of record, or I should say the evidence that we have of record that we think is most persuasive on this is the overseer Porras' testimony. And he tells you both in his written statement and based on his testimony here before the tribunal that it was always contemplated that they were going to not just start the phases but carry them out. And that Guatemala would never have given all of this land to a third party to have them exploit for its benefit without also requiring that they carry out the restoration of the railway. So that's as it relates to the issue of contract interpretation, and I'm obviously not a Guatemalan lawyer, but I understand that's how the issue would play itself out. And if the tribunal is interested in hearing about that more, we would be pleased in post-hearing briefs to talk about the issue of how this would be interpreted under Guatemalan law, because I don't think that has actually been briefed by the parties. On the issue of the letter as to Phase 2, the letter, and I don't have it before me, but it says that they have completed with the initiation of Phase 2 and the rendering of service within 6 months of that initiation. That doesn't, however, in our view, answer the question that I just answered before, which is whether they have to complete it and what they have to do. And I believe that Phase 2 demonstrates the unreasonableness of the interpretation that's been given to this clause by RDC, because, as you've heard, the uncontradicted testimony is that there was some track that was laid down in relation to Phase 2 at the border of Mexico, and the Mexican train and the Mexican operator brings the train in for a certain amount of distance, unloads cargo, and goes back out. To say that fulfills RDC's and FVG's responsibility to restore Phase 2 seems to me to be unreasonable. Now, I realize the letter's there, and the letter, I don't know the circumstances under which it was executed, so I can't offer you any insights about that. But I can say that to interpret that to mean that they then therefore get to conclude that they've carried out the restoration of Phase 2 and that they get to keep that land seems unreasonable. And therefore we'd go back to the initial analysis. And I'd also point out that they were looking into financing for funding Phase 2, and it seems a bit contradictory to say they were done and they had nothing more to do in Phase 2, but at the same time they were looking for financing and funding in order to carry out restoration in Phase 2. Now, in relation to I think the second question was the power and authority of the FEGWA overseer when he signed the letter authorizations and signed I think the different contracts, I believe you were asking about. So we would remit you there to the legal opinion of Mr. Aguilar, and I'll give you my humble explanation as to what I understand the issue to be. In civil law systems like this one, a public official can only carry out whatever powers have been expressly given to him or her. The FEGWA overseer is part of the executive branch, and the FEGWA is part of the executive branch, and therefore the FEGWA overseer is part of the executive branch. And as I understand it, there are certain powers that the executive, its chief being the president, delegates to the FEGWA overseer, and those are set forth in FEGWA's organic law. Article 3 of FEGWA's organic law states that the object and purpose of FEGWA is to provide rail transport service. And as I understand Mr. Aguilar's opinion, nowhere in the organic law of FEGWA has there been a delegation of power to the FEGWA overseer to contract out to third parties goods of the state. The FEGWA property, meaning the railway property, I should say, the railway property, meaning both the land and the rail equipment, is property of the state, as defined by Article 121 of the Guatemalan Constitution. So the opinion of Mr. Aguilar is basically that FEGWA's overseer was never delegated the right to contract out to third parties government land or this government property, and hence, in order to do so, and for that to be valid, there has to be approval by the president of any such contracts. It's my understanding that is why when the first bid was put out, Contract 41, that it required executive approval in Section 6.4 of the bidding terms. And so what that means, and this is what Mr. Aguilar's opinion is that when the letter authorizations were signed by the FEGWA overseer giving property rights, in essence, to RDC, their right to use and benefit from the railway equipment, the FEGWA overseer overstepped his bounds. He didn't have the authority. That authority had never been delegated to him to do that unilaterally. He can do that so long as he complies with the law, and the law requires that the executive approve of any such grants of property interests in state property, such as the land or the railway equipment. Proof of that, in part, is that when Contract 402 was executed, it required government executive approval. And I believe this was a question that was posed by the chairman yesterday. And it's my understanding that Contract 402 not only was approved by Congress, but also had executive approval. I believe that to be correct. And I should say I did not cite all of the provisions that Mr. Aguilar cited for his opinion on this issue of executive approval, but they are set forth in his expert report, and we would remit you to that, and we'd be happy to provide you with those clauses if you'd like to see them. The third question that was asked was in relation to the different contracts for the railway equipment. And I believe, Secretary Eisenstadt, you referenced Contract 41 and Contract 143, and then you mentioned the draft settlement C-44, and you mentioned that there were errors in relation to all three, and had asked, what basically for me to try to explain what happened there. As I understand it, Contract 41, it was signed. The bids, it was signed by both parties, required executive approval, and the lack of executive approval is the only thing that prevented that contract from being perfected and entering into force. As we mentioned in the closing statements, and as was mentioned by Mr. Aguilar yesterday, before there would be even an opportunity to obtain the requisite executive approval, FEG approached the FEGWA overseer and asked for authority to utilize the equipment pursuant to a letter authorization. And that you can see in the record because you can compare the dates when the contract was signed, and you can see that not even 20 days later, FEGWA receives a letter requesting the use of the equipment. The why Contract 41 didn't get approved, I don't have an answer to that. What we know is what's in the record, which is Mr. Porras has said he asked for government approval. I don't know what considerations were given to that by the President and why the President made that decision. You heard from Mr. Aguilar yesterday his understanding as to why he thought it might not have been approved, and he mentioned that it lacked a registration, and that he thought that the President would not be able to approve that agreement for that reason. And you heard from Dr. Mayota that approval's not necessary at all, and that hence when it was sent to the President that there would be no juridical basis upon which the President could approve it. And so he thought the President couldn't approve it because there would be no basis in law for that. We disagree with that. And again, we would point to Contract 402 as the example of approval that was obtained of a similar scenario where state property was given to a third party. But I don't have the answer for you on why it wasn't approved. As to Contract 143, my understanding, and of course the record, you can review it, and obviously the tribunal will come to its own conclusions, is that what Dr. Gramajo was testifying to yesterday is that the agreement incorporated terms, the bidding terms from Contract 41, which require executive approval, but then expressly said that executive approval would not be required for purposes of that contract entering into force. As I understood Dr. Gramajo's testimony, he was saying that he could not submit that agreement to the president for approval because it expressly said that presidential approval was not required. That's not to say that he was of the understanding that that agreement didn't need to be approved. I hope that distinction is clear, because he was told immediately upon being made aware of that contract that presidential approval was required, and as a result, he wrote to Ferrovias and explained that that was a requirement that would require the parties to renegotiate the contract and enter into a different one that would be approved by the president. So I think that's an important distinction. I'm not so sure how clear that came out in Dr. Gramajo's testimony, but that's what I understand the issue to be. Why that agreement itself was never approved, Contract 143, which I believe was part of your question, it was never submitted to the president, as you heard by Dr. Gramajo, because that agreement on its face can't be approved because it suffered from illegalities. It's my understanding, if that agreement would have been elevated for presidential approval, they never would have received it because it suffered from a number of legal defects, and we know that in part because once it came to the knowledge of the legal advisors of the president that contract existed, their analysis of it, which we have in the record, was that the contract suffered from defects that rendered it lesivo. So I don't believe that agreement on its own would ever have been approved or could have been approved by the president, but a separate agreement, if they could have negotiated one that fixed the problems, including an agreement to celebrate a new public bid, I think could have cured the issue. As to C-44, on its face, it's a mistake. I mean, we all know that there was no bid that took place in relation to Contract 143 and 158. And I submit to you that there are probably a number of other mistakes in the document. It's a draft agreement, and what we know from the testimony of Astrid Sosel, again, she is a lawyer from the Ministry of Communications who was involved in relation to the drafting of that agreement, and Mr. Berduo, both of whom have submitted witness declarations here. They say that agreement was put together basically the night before, and then they were looking to negotiate it with Ferrovias, with FEG, on the day of the 24th. So it's not surprising to me that it has a mistake. The next question is on the issue of the standard under fair and equitable treatment and Article 10.5 of CAFTA. And the particular question I believe that you posed, Secretary Eisenstadt, is whether we agree, whether Guatemala agrees that arbitrariness, non-transparency, and legitimate expectations not near me. Mine is off and in my bag. I think mine is off, yeah. Maybe it's somebody else's. Mine is off, but I hear it as well. Oh, you know what? Maybe this thing. I don't know if this. Okay. Is that better? I'll take that to be a yes. So, in relation to your question, so very succinctly, we do not agree that arbitrariness, arbitrary conduct or arbitrariness on its own is part of the minimum standard of treatment under customary international law. However, we do agree that manifestly arbitrary conduct is. And we've cited the tribunal there to a number of opinions. Glamis Gold, which is at RL 102, paragraph 616. Cargill, which is at RL 175, paragraph 296. International Thunderbird, paragraph 194, and waste management, paragraph 98. I believe I gave you the wrong RL numbers, just so the record is clear. Glamis Gold is RL 102, Cargill is RL 175, International Thunderbird is RL 104, and waste management is RL 136. So manifestly arbitrary conduct, we believe, is within the minimum standard of treatment for fair and equitable treatment. Now, non-transparency, we do not believe, is part of the customary international law minimum standard of treatment under Article 10.5, and neither is the legitimate expectations of the the investor, and we would point you there to the text of Article 10.5, wherein it says that the customary international law minimum standard of treatment is the one that applies, and that in particular the CAFTA parties agreed that no additional substantive obligations are to be created beyond that minimum standard. Now, having said that, Secretary Eisenstadt, I believe that, and as we've argued already, that the conduct at issue here would satisfy even those other standards, even though we don't believe they come within Article 10.5. The second and last question, indirect expropriation, you asked whether under Vivendi 3, substantial and permanent deprivation of claimants' interests in the enjoyment of their property would be sufficient, and again, we believe it has to be a substantial deprivation of their property interests in their investment, and it has to be sufficiently substantial such as to constitute the equivalent of a full expropriation. And you know, I think we've cited a number of cases in our brief in relation to that issue. The last question I have already answered in some detail, so I'll try not to repeat much of what I've said, but I'll leave you with this. The question, as I understand it, was why was the government spending time focusing on issues in relation to Contract 402 and 820 in the settlement discussions leading up to the Lesivo Declaration? And the answer to that is what I stated earlier. There was a fundamental series of problems between these parties, and claimant, through their enterprise FVG and through Mr. Posner and others, asked President Berger for a meeting, and the purpose of the meeting, as I understand it, was claimant wanted to get the intervention and assistance of the President to resolve the problems it had in relation to the relationship. And there were a number of them, and there's a presentation. I don't know if any of my colleagues can get me no, I don't want to put the presentation up, but just the site to the presentation that was made by Mr. Posner during the meeting. But I think it's very telling, because that'll show you what the PowerPoint slides were and what issues he was raising at that meeting. And I think when you look at that PowerPoint slide and you look at the notes that were made by Mr. Posner following the meeting, what you'll see is that he was talking to the President about a number of issues. I believe C33 is the site to the PowerPoint presentation. And the issues under discussion were a number of them, and they included the lack of funding for Phase 2, the problems with squatters, the problems with the trust fund, and a number of things. So it's no surprise that as a result of that meeting, and starting then and afterward, when the President took up Mr. Posner on his request to intervene and help, that the government officials that were involved were discussing all of those issues and not just Contract 143 and 158 in isolation. as I also pointed out before, that's not the first time that FVG had sought intervention at a higher level in the government. We pointed to R9, which is the letter to Vice Minister Diaz, which was copied to President Berger, wherein they were seeking help with a number of issues, including funding for the Phase 2 Southern Coast, removal of squatters for Phase 2, payment of trust fund payments, and remedying Contract 143 and 158. I think that letter is fairly instructive because claimant in that letter puts all three issues on the table and asks for assistance from Vice Minister Diaz from the Ministry of Communications. I hope that responded to your questions.
I just wanted, I had asked if FEGWA ever factually made a payment into the 802 trust fund.
My understanding is that FEGWA has not made payments into the 802 trust fund. That is the subject of the arbitrations in Guatemala, excuse me. I hope that responded to your questions. Let me make sure my colleagues don't have any other points. If you just bear with me half a second. We don't have anything else unless the tribunal has other questions. Thank you.
Mr. Foster asked to say a word.
Extremely briefly in response. First, on the issue of the approval of Contract 402, there was no presidential approval. There is nothing in the record that indicates presidential approval. If you look at Exhibit C20, you will see that there was congressional approval, but no executive approval of 402. Secondly, with regard to the terms of Article 13 of Contract 402 concerning the obligation of Ferrovías to do repairs, number one, in Phase 1, in contrast to what you just heard, if you just read it, it requires the renovation of the railroad all the way from Guatemala City to the port. It is not the same obligation as relates to the other two phases. But the obligation in Article 13 has to be understood in terms of the other provisions of the contract. We were only obligated to invest $10 million. For someone to say that there was a reasonable expectation, regardless of the words of the contract, that somehow or another there was an expectation that we were going to renovate the entire railroad, that one doesn't pass the red face test. Also, remember again, it's a 50-year contract. The contract explicitly says that other actions in addition to the specific obligations of the contract will be done as business conditions permit. So the contract explicitly contemplates that as we go through the 50 years of this usufruct, business conditions may well justify investments in addition to the minimum requirements under the contract. Also, the letter from the overseer doesn't just say that you've satisfied the beginning or anything, the startup obligation. It says that the obligations of subsection 3 of clause 13, that's the clause that refers to the obligation in connection with phase 2, says that all of those obligations have been met. So it's not just saying you began service on a small segment. It is saying that what you have done so far meets your obligations under clause 13 with regard to phase 2. Third, on fair and equitable treatment in the standards, I would just refer you to the following slides in our opening presentation for our position with regard to what the standards are, and I won't take your time by going through them. But insofar as arbitrariness, if you look at slides 62 and 63, bad faith, slide 58, due process, slides 59 through 61, and legitimate expectations, slides 64 and 65. That's set forth what we believe the standard under customary international law is with regard to fair and equitable treatment. Now, finally, on the issue of what went on at this meeting with the president and what that has to do with the whole interplay that was going on at that time, what is extraordinary about the meeting with the president is that not what was discussed, but what wasn't discussed. There was never a mention of the fact that there were illegalities in contracts 143 and 158, or that there was any Lesivo process even being considered. That's the key point as to what was happening at that presidential meeting. And I'll stop there. You've been very patient with us, and thank you very much.
Thank you, Mr. Foster. Mr. Orte, have you anything
In
to
the
add?
in the
since
interest
you have
of
spoken
allowing
about-
you more time to ask additional questions or deliberate, I have nothing further.
Thank you.